today that we're going to have the hearing, just to be cognizant that there's several of you. I'm going to put a 5-minute limit on each speaker, and just understand if you're going over, then you're taking away from somebody else's time. When you're speaking, if you're remote, which it looks like all of them are, I'll give you a 1-minute warning. It's the timing thing has been a little awkward with the WebEx. So I'll give you a 1-minute warning, and that'll give you a chance to wind down. So I'll open the hearing on House Bill 2371, and I will turn it over to Jesse for an overview of the bill.
Thank you, Madam Chair. Good afternoon, committee. Today's hearing is on House Bill 2371, which changes certain requirements to receive public assistance. KSA 39709 sets the requirements to receive TANF, food, and child care assistance, and more. So currently, KSA 39709 currently requires that recipients of TANF, food, and child care assistance cooperate with child support services. House Bill 2371 would no longer require those receiving or applying for child care assistance to cooperate with the child care support services. And this statute currently states that those who are not cooperating with child support services, but for good cause, are ineligible for food assistance. And under this bill, all those not cooperating with support services would no longer be ineligible. That language is struck. And additionally, under subsection B16, capital B, it states that the Secretary of the Department for Children and Families shall adopt rules and regulations to determine and maintain eligibility for child care assistance, including the requirement that all adults shall be employed for a minimum of 20 hours per week or more to receive the assistance. But there are some exemptions to this 20-hour per week work requirement, and House Bill 2371 would add an exemption to that list for adults enrolled in a public or private elementary or secondary school or post-secondary educational institution. The bill also strikes all the language imposing requirements on adults enrolled in post-secondary education for assistance eligibility and a lifetime maximum amount. This bill would take effect upon publication in the statute book. And I'm available for questions on House Bill 2371.
Okay, thank you, Jesse. Committee, do we have questions for Jesse on the bill? Representative Astley.
Thank you, Madam Chair, and thank you, Jesse, for the overview. And I apologize for not doing my homework upon this, but the last sentence, this bill also strikes all language imposing requirements on adults enrolled in post-secondary education for assistance eligibility and a lifetime maximum amount. Does that mean that while they're enrolled in school, these services would not apply to the lifetime limitation?
Yes, no, it's striking that language would no longer impose a maximum amount on the benefits that could be received by someone enrolled in post-secondary education.
Okay, I'll listen along. Maybe I'll gather a little bit more understanding as we hear from the conferees. Thank you. Thank you, Madam Chair.
Okay, so first up we have Elizabeth Cone, Director of Child Support Services at DCF, and following her will be John Wilson. Are you there, Elizabeth? Good afternoon.
Food assistance is a program that provides immediate help. Can you hear me?
You're breaking up really badly.
It's a program.
Hey, hang on just a minute. Can you turn your camera off? It will help us to be able to hear you better without breaking. It might help it. not good. Sorry. Do you have any other ideas?
If you can't, can you hear me? Would you prefer that I call to?
No, we only hear just, okay. Go ahead and do that. John Wilson, do you want to go ahead and go?
And after.
Madam Chair, I'm happy to go while Elizabeth works out the audio issues.
Okay, great, thank you.
You bet. It's good to see everybody today. Madam Chair, members of the committee, thank you for the opportunity to testify in support of House Bill 2371. My name is John Wilson, and I'm the president and CEO of Kansas Action for Children. And our goal is to make Kansas the best state to raise and be a child. And I should also say I'm a member of the Governor's Education Council and the Kansas Children's Cabinet and Trust Fund. The COVID-19 pandemic and economic recession has amplified the extreme hardships that many parents have experienced for years in Kansas due to statutory requirements that restrict access to work and family support programs. We believe House Bill 2371 is a modest and common sense step toward removing those restrictions that parents and caregivers face, and can help them put food on the table, enroll their children in childcare, get an education, and ultimately regain their financial footing. Our team at KAC has spent decades tracking the well-being of kids, and we've noticed a couple of alarming trends that were in existence even before the pandemic, and I'll be brief about these. Too many kids in Kansas live in poverty. Statewide, a little over 100,000 children live in poverty, and that means a family of three would earn $21,960 or less in Kansas. Furthermore, too many families cannot afford childcare. The average annual cost of infant care in Kansas is $935 a month, so coming out over $11,000 a year. And for 4-year-old care, it's about $733 per month. Finally, we know that simply too many Kansas children are going without based on an unprecedented and comprehensive study done for the All In for Kansas Kids campaign, where they went to all 105 counties and heard from more than 6,000 Kansans. And through that research, they uncovered that too many young Kansans are growing up in families where their basic needs are not being met. So without meaningful intervention from lawmakers, we expect to see these problems get worse. And as if that weren't enough, the pandemic has created incredible social and economic disruptions, especially for women. We've seen that women are disproportionately represented in low-wage jobs, and working mothers are more likely to reduce their hours or leave their jobs to take on caregiving responsibilities when there are disruptions to childcare. More must be done to support working mothers, and we think the provisions in House Bill 2371 are a step in the right direction. Jesse's already done a terrific job laying out the components of this bill, but I just want to highlight a couple of things. The first component of the bill is that it eliminates child support cooperation requirements for the food assistance program and the child care subsidy program. You might hear conferees refer to that as SNAP and child care assistance. They're the same programs. Kansas is among the few states that has this provision, and this provision is not required under federal law for these two programs. This requirement has a chilling effect on participation, and there are good reasons why it might not be in a family's best interest to pursue child support. As Jesse noted, there is a process for applicants to share why child support enforcement could endanger them or their children, but we found that presence of the question is a deterrent in and of itself. Another component of this bill, exempting students enrolled in public or private K-12 education or post-secondary educational institutions from the child care subsidy program work requirement. The federal government does not require that parents work a minimum number of hours to qualify for child care subsidies, and Kansas is one of only 10 states with a minimum weekly work requirement for parents in post-secondary education to be eligible for child care assistance. We believe minimum work requirements can make it difficult for parents to maintain eligibility given unpredictable work schedules, especially for low-wage work, and especially when combined with school demands. And then the last piece, removing requirements and restrictions imposed on students pursuing post-secondary education to receive child care subsidy. Kansas is one of 7 states with enforced time limits on post-secondary education or training, It's one of only 4 states that requires students to maintain a GPA, and is one of only 2 states that limits childcare assistance for post-secondary education training to only 1 parent in the household. I think these are all really important statistics and facts to show that Kansas is out of step with the majority of states around the country. We don't believe the limits listed above work to promote work or help parents and children. Instead, they can drive families deeper into poverty. And while we believe much remains to be done to help children and families, these simple changes would support our fellow Kansans as we all recover from the pandemic. Again, thank you for the opportunity to provide testimony in support of House Bill 23 and for creating the space for the important discussion. I also want to have a quick shout out to Fran. Fran, thank you so much for organizing this hearing and the testimony. With over 30 pieces of proponent testimony from around the state, I recognize that's a lot of work.
Yes, we all thank you, Fran. Thank you, John. We're going to save questions to the end. We'll go back. Do we have Elizabeth yet? Okay, we'll move on to Cecilia Douglas, a parent and advocate. Cecilia?
Hello, I think I'm unmuted now.
Yeah, we can hear you now. Welcome to the committee.
Wonderful. Thank you so much. I appreciate your time. Yes, so my name is Cecilia Douglas. I'm calling in from Garden City, where I have 3 children. I have 2 teenage daughters and a toddler who is just fascinated with all things boy. I am here in support of House Bill 2371. I strongly encourage the adoption of the proposed legislation. Firsthand, my experience, it was negative. I spent over 10 years as a single parent to my kiddos, my daughters. I was a young mother. I knew that with my high school diploma, my options were limited. I knew I needed to fight hard, work hard, to really give my children what they needed. That required a little bit of assistance, which I knew was temporary. So I did rely on SNAP benefits and childcare assistance for my older 2. I worked hard at a local radio station, building relationships and doing what I could to make sure that every time I moved a little forward, it was with the idea that I was going to find self-sufficiency. I needed to become self-sufficient for my children. I knew that there were barriers I was facing as a young single parent, and the assistance that was offered to me provided food for my children when I needed it. It provided me childcare, high quality childcare, so I didn't have to worry about them while I was working. Rather, in 2013, I finally got to the point where the Department of Children and Families informed me that I made too much. Rather than being upset, I took this information and I felt empowered. I had finally achieved self-sufficiency for my children. Now, in 2017, it was an entirely different story when I found myself pregnant. This was a planned pregnancy. My partner and I had been together for 3 years. We experienced miscarriage. So my second son was definitely a blessing, so I thought. My child's father had emotional issues that prevented him from being able to hold down a job. He spent money excessively, leaving me in crippling debt when he finally decided to leave about 5 to 6 months into my pregnancy. I didn't know what to do. I had accepted a position that was a lot less money, but offered flexibility so I could attend my doctor's appointments and maintain rest when necessary. So losing that second income did not leave me a lot of options to provide for my family, let alone taking care of myself. My health was failing during that pregnancy. I relied heavily on peanut butter sandwiches and Ensure shakes. during the pregnancy with my son because unfortunately we were very limited financially. I did try to apply for assistance. At that time, we were told that we didn't qualify because of the house size and the income guidelines. Despite the fact I had crippling debt, they were looking at my gross income. So I wasn't able to provide those basic needs for my children, even while I was pregnant. It was frustrating. 2017, when my son was born, I went ahead and logged on to fill out an application for assistance. I had got through the entire process, and then there was a consent that was necessary to proceed with the application, and it was for a child support enforcement order. And I felt off with this concept because I have a child support enforcement order with my older two, and it's been in place for as long as I can remember. I received.
Cecilia, you're at 1 minute.
Okay, thank you.
Thank you.
My hope is that the information that I've provided today to this committee resonates as you move forward. It's difficult out there providing for children on a limited income, and having a stipulation that gets an absent parent involved is problematic in a lot of situations. So again, thank you so much for your time and attention today, and I'm happy to stand for questions at the appropriate time.
Thank you, and sorry to have to interrupt you. Next up is Kelly Davidoff, Child Care Aware of Kansas.
Good afternoon. Thank you, Madam Chair and members of the committee. It's really a pleasure to be able to join your discussion this afternoon, and I'm grateful for the opportunity to provide testimony in support of HB 2371. My name is Kelly Davidoff. I'm Executive Director for Child Care Aware of Kansas. We are a network of child care resource and referral agencies that work together to ensure all young children and their families have access to high quality early care and education in Kansas. I'm happy to support this bill on a number of fronts. First of all, it would positively impact young children and their families by easing access to child care subsidies, as well as alleviating child and family food insecurity. According to the All In for Kansas Kids Needs Assessment that was just completed in January of 2020, 1 in 5 Kansas kids lives in a family that's experiencing poverty at 100% of the federal poverty level or below that. That's 20% of our young children living in poverty. And when we look at the child care subsidy program, we're only reaching about 12% of those kids living in poverty with that assistance. That means there are a lot of really, really vulnerable young children in Kansas that are not getting the support and the assistance that they need in order to access high quality early care and education. This bill eases some of those potential barriers to accessing child care assistance, and for that reason is such an important measure for this committee to entertain and to consider. Anything that we can do to improve parents' ability to work towards economic self-sufficiency and to ensure that kids can access high quality early care and education is a win-win for Kansas all the way around. And this bill supports both kids and families. I'm so pleased that we're considering this, and again, anything that we can do to improve access to child care subsidy is really going to benefit kids in the state. And I'll keep my comments brief today, but just I'm so grateful to be able to offer testimony in support of the bill, and again, happy to entertain questions at the appropriate time. Thank you.
Kelly. Next up, Haley Cutler from Kansas Appleseed.
Thank you. Can you hear me okay?
Yes.
Excellent. Thank you, Chairwoman Concannon and members of the House Committee on Children and Seniors for allowing me to be here today. We really appreciate it. My name is Haley Cutler. I'm a campaign director for Kansas Appleseed Center for Law and Justice. We are a nonpartisan nonprofit organization dedicated to the belief that Kansans working together can build a state full of thriving, inclusive, and just communities. Kansas Appleseed supports HB 2371, ending the requirement of cooperation with child support from eligibility requirements for food and child care assistance, as well as exempting adults enrolled in school from the 20-hour per week work requirement, will likely result in more cooperation with child support and will also improve the lives of children caught in the midst of custody arrangements. We should all feel a profound sense of urgency to pave the way for a stronger, more resilient state, especially right now. Ample programs and policy solutions already exist to strengthen not only our state's response to the COVID crisis, but also to our state's response to hunger. As Kansans, our communities are what many of us hold most dear. Yet as COVID-19 has continued to sweep through these communities, too many of us are being left behind. And I know we were talking a little bit earlier, other folks were talking about food insecurity. Currently 1 in 6 Kansans are food insecure, and this number is even higher among Kansas children, as we just heard. SNAP food assistance is one of the best ways we can help lift families out of poverty and send them towards hopeful futures. SNAP benefits are an essential part of increasing a family's overall budget. Reducing families' budgets puts children at an increased risk of food insecurity and inadequate nutrition, as well as a greater risk of suffering long-term consequences to their educational achievement and their health. Additionally, SNAP generated an estimated $631 million in economic activity in Kansas, while also creating or saving an estimated 8,500 jobs just in the last month. So that's just in the context of the coronavirus pandemic. So currently, Kansans applying for food assistance must indicate that they'll operate or cooperate with child support. This may force them to come in contact with a former abusive partner or someone who doesn't have a connection to their child for other important reasons. This risk prevents people, especially mothers, from applying for SNAP in the first place. House Bill 2371 would remove this barrier and improve access for parents working to support their families. And for this reason, Kansas Appleseed supports HB 2371. I also wanted to let you all know, members of the committee, I have emailed you information about food insecurity and SNAP participation rates. Those should be in your email inbox just a little bit ago. So thank you again, and I'll stand for questions at the appropriate time.
Haley. I think I'll jump back and see, is Elizabeth on the line? Elizabeth Cohn from DCF.
Chairman, this is Sandra Kimmons from DCF.
Yes.
Elizabeth is not able to get on. I would prefer to submit the testimony as written, and I will stay on and be available for any questions for the agency.
Could you state your name again?
Yes, Sandra Kim, Director of Economic and Employment Services.
Okay, thank you. So
Thank
next
you.
up we have, next up is Michelle Johnson, Motoyama from Ohio State University.
Thank you, Madam Chair.
Thank you. Welcome to committee.
Thank you. I appreciate this opportunity to provide testimony in support of House Bill 2371. My name is Michelle Johnson Motoyama, and I'm an associate professor at the Ohio State University College of Social Work. A large body of research has demonstrated the pernicious ways in which economic strain and food insecurity affect family functioning, including a family's ability to care for their child's basic needs and to provide a nurturing and safe environment that's free from violence. In my research with Professor Donna Ginther at the University of Kansas, we've been examining the effects of state social safety net policies, such as SNAP, on child abuse and neglect during the Great Recession, which began at the end of 2006 and continued to ripple through the U.S. economy as late as 2013. SNAP has been recognized as a critical near-cash stabilizer of child and family well-being during economic recessions. And in our research, which has been funded by the Centers for Disease Control and Prevention, and is currently under peer review, we find that state SNAP policies play a significant role in preventing child maltreatment and foster care entry. For example, in our national study, we find states with higher counts of disqualifying policies, such as non-cooperation with child support, experience a 3.6% increase in child maltreatment reports when compared to other states without such policies. These findings comport with past studies that suggest even small amounts of income can prevent contact with child protective services among families with limited resources, and that's even when effects on SNAP caseloads may be negligible. Notably, the costs of SNAP benefits are small relative to the direct and the indirect costs of child maltreatment and foster care. While states may be inclined to find ways to reduce program costs, particularly right now during the pandemic, our findings from the Great Recession suggest that limiting access to SNAP results in harm to children and considerably higher costs to taxpayers in the long run. Conversely, policies that increase access to SNAP and boost SNAP investments may see important protective effects for children, families, and also for state budgets. For example, if we convert our study estimates into caseloads, we find the addition of a single income generosity policy, such as eliminating child support cooperation requirements as proposed in HB 2371, could reduce the number of children entering foster care by 7.3%. Based on our estimates, this translates into approximately 390 children at the sample mean. The average monthly cost of a foster care payment for one child in Kansas is approximately $2,000 per month, and children spend an average of 20 months in care. Therefore, foster care costs for 390 children equal approximately $15.6 million. For the same number of children, the cost to the average monthly SNAP benefit for a family of 3 at $401 for 20 months is approximately $3.1 million, considerably less. Notably, foster care payments represent just a portion of the human and the societal costs that are associated with separating children from parents. Our findings suggest that to prevent increases in child maltreatment in foster care and to protect state budgets, it's in the state's best interest to maximize program access and generosity to address basic human needs. In the context of the COVID-19 pandemic and economic recession, these findings underscore the critical importance of the SNAP program for children and families, as well as the potential unintended costs of state SNAP policy choices, in this case, which we can think about as potential cost savings in the long run to the state through increased access to SNAP. In closing, to date, the U.S. Congress has passed a number of coronavirus-related legislative actions to enhance unemployment insurance, to increase federal funding for Medicaid, and also to increase food security spending. However, recent reports suggest that existing measures have really not been sufficient to stave off food insecurity or to bolster resources for household spending, for rent, for childcare, or for mortgages. Additional federal investments are going to be necessary to stabilize income, and concrete supports must be a priority. In the meantime, past research suggests that the actions that states and localities take now to support families in need matter for child maltreatment prevention. Policies that increase access to programs such as SNAP and child care subsidies are likely to have a positive effect. Therefore, these concrete supports to address basic needs should be among the top priorities at the federal, the state, and the local levels to prevent child maltreatment as well as other forms of violence. I'd also like to mention that the COVID-19 pandemic, the national reckoning on racial justice, also illuminates the historic dynamics of poverty and inequality and presents us with the opportunity to examine how we might better address the fundamental needs of children and families. I support House Bill 2371, and I'm happy to answer any questions you may have at the appropriate time. Thank you.
Okay, last but not least, Sarah Rust Martin, Kansas Coalition Against Sexual and Domestic Violence.
Thank you, Madam Chairperson, members of the committee. I appreciate the opportunity to be with you today. I am Sarah Russ Martin, Legal and Policy Director with the Kansas Coalition Against Sexual and Domestic Violence. We represent the 26 advocacy programs that serve victims in local communities across Kansas. And on behalf of them and the coalition, we strongly support the passage of House Bill 2371. The most important components of the bill that apply to victims of domestic and sexual violence are the child support enforcement provision and the SNAP and affecting SNAP and child care, removing the minimum work requirements for someone to attend secondary education, and removing the lifetime limit for child care assistance. When victims leave abusive relationships and seek independence, this is often a very dangerous time and requires intensive safety planning with a trained advocate. At the same time as safety is addressed, so are the other issues that are facing the victim for many times in a very real and profound way, which is limited time within a shelter is possible, but that is, again, a limited time. And at that point, when that time is up, there will be an exit strategy. And it will be upon the victim to determine how to support herself and or her children. It is in that time that victims often have to face a very difficult reality, which is that financial insecurity, and meaning financial insecurity, meaning food insecurity, housing insecurity, it's really across the board. And the number one reason that we see for victims returning to abusive relationships, so often we hear, why doesn't the victim just leave? Well, in many cases, the victim does try to leave. And financial insecurity is one of the top reasons why a victim is not able to sustain that. Because there is not the opportunity to secure childcare, to secure affordable housing, to feed children, to do all of the things that are necessary. And we believe, just like other proponents here today, that what is best for families is best for Kansas. And we know that it is best for Kansas for those who are seeking safety and justice and health to be able to have that option and to be able to make that work. And under the current scheme, that is not possible. For those reasons and more, but I'll contain my time, we support strongly House Bill 2371, and I'm happy to stand for questions at the appropriate time.
Thank you, Sarah. So committee, we have 29 proponent written testimony. I'm not going to read those off, but you can find them. Did you email them? Okay, you can find them on the website. So do we have questions for the proponents? Representative Esau.
I don't know who I would be addressing this to specifically, but I would be curious if anyone, and you could just email me if no one has anything off the top of their head, but if there should be any kind of minimums for being enrolled in post-secondary education that you'd be comfortable with, that is something I would be interested in hearing.
John
Sure.
Wilson, you want to address that?
Yeah, I'll take that. I appreciate the question, Representative. One of the reasons that this bill excludes those minimums is there's actually a couple of reasons. One, we know that first, for students who have small children, they're likely to take much longer to complete their education, which is why we removed the lifetime limit. And as it relates to the work requirement, to be eligible for child care subsidy in the first place, you have to be have relatively low incomes, which means you're most likely working some amount. And so by removing the minimum requirements, we provide that flexibility that families and parents need. And we also reduce some of the administrative burden on the agency, which ultimately saves the state resources.
Representative Ousley.
Thank you, Madam Chair. I'm going to take a stab at this for Michelle Johnson Moriyama. You had mentioned that you and Dr. Genta's studies were still under peer review, and I was just curious to how long of a process that is because I know nothing of peer review.
Yes, I'm happy to share that information. Typically, it can take anywhere for from 3 to 6 months for an article or manuscript to move through the peer review process. It can take another, perhaps 3 months for publication.
Do you have any idea of the status of it currently? Can we look forward to a publication soon?
I hope so. It's currently under review. And I hope that we would, with the journal that we're submitting to, it's a quicker one. So hopefully it would be something that could be published relatively soon. Unfortunately, I can't give a date.
Okay. Well, I thank you for being here and thank you for your work to all the conferees.
All right. Thank you very much.
Other questions? Representative Smith.
Thank you, Madam Chair. I hope the question makes sense. I was wondering, what if you had a motivated parent? How much money could they make before they had to leave this program? Does that make sense?
So, Representative Smith, or Madam Chair, I'm happy to respond.
Yeah, go ahead, John.
Representative Smith, first of all, it's great to see you again. And I'll say that first, I think every parent or caregiver enrolled in SNAP or the Child Care Subsidy Program are motivated people. I think families with low incomes are some of the hardest working people with the largest amount of responsibility for how they spend their funds because they have to account for how every single penny is spent. So to the point, to your question about if they're motivated, how much can they make off of this? I don't think anybody is making money. This is barely keeping families afloat. So when combined, resources from the Child Care Subsidy Program and the Food Assistance Program helps make ends meet so that they can put food on the table and afford really expensive childcare in Kansas so that ultimately they can go to work and that when they are at work, they are focused and productive employees because they don't have the stress of not knowing can they put food on the table and can their kids be enrolled in high quality early learning opportunities.
Thank you. Thank you, Madam Chair.
Thank you.
Representative Wagner.
I'll direct this to one of the people, but first I want to know who brought up this bill? I mean, who's this bill officially sponsored by? I mean, do you know perchance? I mean, I'm just generally curious. Just
Yes, Kansas Action for Children brought it to us, and we, as a committee bill.
Okay, fair enough. Then let me address my question to the man or the gentleman from Mr. Wilson. So, I've only been here for a few years, so I'm not totally familiar with what had happened with previous legislation. Though, just reading between the lines, my guesstimate would be that these were protocols put into place that would, before we put the taxpayers on the hook for something, that we look for money from child support, and so I guess my initial question: do you not think? I take it you must disagree with that, or do you think the taxpayers' interest? I don't quite see being considered at all, or it seemed like the previous position was to consider the taxpayer interest in going after what, in the vernacular were called, deadbeat dads typically, but just that avenue of income for the family should be pursued first before you go looking to the taxpayers. I mean, I'm taking it that you think that it's a bad philosophy to approach these questions with.
Thanks for your question, Representative Wagner. I don't think it's a bad approach. Here's what I would say is that the Child Care Subsidy Program, the Food Assistance Program, and the Child Support Program are all important programs to help lift families out of poverty. And I think for the vast majority of families enrolled in nutrition assistance, and child care subsidy, who also have child support enforcement orders. People are complying with those. So for those who aren't complying, it's likely because they're really poor, and it is difficult to comply with a child support enforcement order if you don't have funds. So philosophically, we believe that withholding nutrition assistance that allows families to put food on the table, or preventing kids from entering high quality childcare, is the wrong way to incentivize child support cooperation. And there are other ways to do that. So all of the programs, all three of those programs, can help lift families out of poverty. The other thing I would mention is that 100% of the SNAP benefits are paid for by federal dollars. And it's about a 50-50 split for administration of the program between state general fund and federal dollars. And for child care subsidy, the majority of the funds come from the federal government to support that. So when we put these state level barriers on these programs, we are actually putting in place barriers that don't exist at the federal government, and we are limiting access to these programs that are paid for by and large by federal dollars.
Representative Penn.
And Mr. Wilson, I will rejoin to that. The federal government doesn't provide a service or build an item that people are buying hand over fist. The way that they get that money to release to the states to pay for this 50% or 100% or whatever percentage that you're letting us know is because they tax the people of Kansas, put it into that pot, and then redistribute that wealth out. So the Kansas taxpayers are still paying for this under the aegis of the federal government. It is still a tax on Kansas taxpayers. And what I wanted to ask you was, is there any other, and it's not only for you, Mr. Wilson, but any other respondent or conferee, is there any other program that we have in Kansas that allows a person who is supposed to be paying child support to renege, ignore, or default on that responsibility to their children and shift the burden of their responsibility to the Kansas taxpayer?
Is that directed at John Wilson? John?
Yeah, so I think I could address parts of that question. Thank you, Representative Penn. The first thing I would say is that I don't know the full program requirements for all the programs in Kansas, but what I will say is that whether it's the federal government or the state government, ultimately we're going to be paying the cost. We could either pay the cost up front through prevention by making sure kids in their earliest, most formative years of their life have access to life-saving nutrition and high-quality early learning opportunities. That's a better investment than paying for it down the road with state general fund dollars. So I think that's my first point. The second point I'd make is Kansas, unfortunately, as a state, is still turning away far too much federal dollars. So Kansas taxpayers, you're right, are paying federal taxes, but we are not getting as much back as we could. We're one of the few states that doesn't draw down the maximum amount of federal funds for the child care program. We also haven't expanded Medicaid that can provide health insurance to upwards of 150,000 Kansans. So we are paying taxes for a program that we're not benefiting from. So I would say that all of these programs are state and federal partnerships. And when we remove state level barriers, we could take advantage of that federal partnership in better ways. And there are still non-statutory ways that we could encourage child support cooperation beyond withholding food and high quality early learning opportunities. Thank you.
Madam Chair, may I? And I'm sorry, maybe my understanding is off. As I look at this page 5, line 26, 27, it says individuals who haven't cooperated with good cause for their child support services shall be ineligible to participate in the food assistance program. This is what the language before this would currently read and how it's currently stated. Are there individuals right now that have not paid their child support that are in possession of children, and those children are being refused food, care, and services? Is that your position?
Madam Chair, and Representative Penn, appreciate the question. I think it's important to note that the current Kansas law doesn't remove the nutrition benefit from children. It removes it from the eligible adult. But I would also say that this affects the entire household food budget. And which we know that children don't raise themselves. Infants don't raise themselves. toddlers and 3 and 4-year-olds don't raise themselves. They need supportive adult caregivers in their lives. Sometimes it's their parents, sometimes it's a custodial parent, sometimes it's a relative. And in order to provide the best care for children, we need to make sure adults can meet their basic needs, or else it's going to have dramatic and lifelong impacts on their health and development that cost the state money in the long run.
And thank you, Madam Chair. This is my final question. I'm so sorry to bogart time. I'm just trying to think about how this plays out. If I'm reading this language correct, the one that you want to strike, I would say that that individual, let's just say as the representative made mention of earlier, deadbeat dad, if I haven't paid my child support, I would now be eligible under this new language to have access to those funds in order to feed my offspring. The question that I have for you is, according to TANF, according to SNAP, is that considered income that is reportable and would kick the mother of my children off of the program because now she's getting support from me that reaches a certain threshold?
So, Representative, you might have to talk to the Department for Children and Families for the details of that program. But I would say that one of the items that you mentioned was kind of increasing household income. There are one of the ways in which you could address people not complying with child support enforcement orders is you could address the household income limits for the custodial parent. So if they're not receiving child support, you could potentially lower their household income by the amount that they should be receiving from the non-custodial parent, and then that could make them eligible for a program that otherwise they would have higher incomes and be ineligible for. So again, these are ways that you could do that without having these really harsh restrictions built into statute.
Yes, sir. Thank you.
I would encourage folks from the Department for Children and Families to weigh in at the appropriate time.
Very well. Thank you, Madam Chair, and thank you, sir, for the insights. I appreciate it.
Thank you, Representative.
All right, seeing no more questions, we will move on, and that closes the proponents for this hearing. I show no neutral. So next up, we have Stephen Green speaking for opponents with Opportunity Solutions Project.
Keep talking. There we go.
There you go.
Thanks.
Welcome to committee.
Thank you. And I'm going to leave my mask on because I feel like I'm pretty close to people, so I'm sorry if I'm muffled. I just want to say first, there are some great legends of economic assistance and child welfare that went before me. Sandra Kimmons, Elizabeth Cohn, just great people at the department. John Wilson as well, much respect for them. I think what you'll see is this is a circumstance or a situation in which good people with good intentions fundamentally may disagree on public policy related to this. I'll try to not read off my testimony as much as possible, but what I really want to point out for you all today is that I work for Opportunity Solutions Project. Name is Steve Green. I forgot to introduce myself. We help advance federal policies that improve and sort of celebrate the power of work so that people help realize the American dream. We're going to oppose this bill for a couple of reasons, which I lay out in my testimony. What I want to set out is really that there's two reasons why we're going to oppose it, or why we oppose it. First, that might seem reasonable to eliminate the work requirements for child care subsidy, but as others have pointed out and alluded to, this bill sets no requirement for education participation, neither in hours nor, importantly, if somebody needs to even attend classes to begin with. And I'll highlight that in a second. The other thing is that by eliminating the child support cooperation for SNAP applicants, it might sound helpful, but in reality, as others have alluded to, it means less money going into the pockets of families' budgets that need it and that are frankly sort of legally obligated to receive through child support judgments. In 2015, and I'm going to, before I go too much further, just want to say this is why I think what's currently on the books is good policy. So in 2015, the Kansas Legislature passed the HOPE Act, which was comprehensive welfare reform, making a person ineligible for SNAP assistance if they refuse to cooperate with child support enforcement without good cause. That good cause is actually an important term in this discussion. A person could be immediately eligible for SNAP if they showed good cause. In essence, and so what was the impact of this policy? I referenced an article below, but in the first 6 months of requiring child support cooperation, a study showed that there was actually a 40% increase in collections. That means 40% increase in dollars going into the pockets of families, which is something that we need to highlight as we talk about this. The current law has a provision of good cause, meaning the law provides good cause exemptions when such cooperation isn't in the best interest of the child, such as when there's a risk of domestic violence. And children, as Mr. Wilson noted, will never be sanctioned for their parents' decision not to cooperate with SNAP. So with such a low impact, or with such a positive impact, it's hard to understand why maybe we'd pursue legislative, striking the language that's currently on the books. Also related to child care subsidy, it has a provision that they would not be required to participate in work if they are adults enrolled in a public or private elementary or secondary school or post-education institution. It's important for the committee to understand that the Opportunity Solutions Project is not against low-income families from receiving child care assistance. Child care subsidy is an important assistance program for parents who need child care while they work or attend school to pursue a degree or certification. But that's not what this bill proposes. Instead, as drafted, an adult enrolled in a secondary or post-secondary educational institution is exempt from the work requirement. This means, hypothetically, if this bill was passed, a person could enroll in 1 hour elective at a state college in the history of video games and be exempt from the work requirement to receive child care subsidy, and there's no time limits on it. So somebody could literally enroll in 1 credit hour year after year after year and still be exempt from the work requirement as the bill is currently drafted. I want to close with a couple observations about this bill and the state of welfare in Kansas. First, draw your attention to the fiscal note. There is an impact. One thing it doesn't consider is if the collections for child support would go down, which, based upon the study that was published in 2017, I think is a fair consideration, is what the impact of collections would be. The other thing is that we were told in 2016, 2017, that this was having a serious impact on the child welfare system, specifically that these sort of reforms were going to lead to more children coming into the foster care system, which is a very serious charge and something that we honestly want to be aware of. I will just point out that in the governor's budget and in the DCF's budget with consensus caseload estimates, they actually are projecting the foster care out-of-home placements to be going down. And this is the point while HOPE Act statutes are on the books. So I just want you to have that for consideration as you think about this. Thankfully, it does not appear that the dire warnings of keeping the HOPE Act on the books materialized. I'll just note there's a lot of passionate people that have spoke before me. I have nothing but the absolute respect for them and the organizations that they lead and speak for. I'm just thankful to be a part of this conversation. And while I would ask that you would not support House Bill 2371, I do just want to say thank you and just celebrate the good work that so many people are doing in this area. So thank you. I'm happy to stand for questions at the appropriate time. Thank you, Madam Chair.
Thank you, Stephen. This would be the appropriate time. So, Representative Esau.
Excuse me, thank you, and thank you for being here today. If there was a minimum, say, you had to be enrolled in 6 hours and you could only qualify for a certain number of years, something like that, would that alleviate some of your concern about the bill?
So I mentioned this in the testimony, but we are in the position that the current statute that's on the books is that right balance in which I would suggest that the closer somebody gets towards the next level of job training or certification, the sooner. And Mr. Wilson noted that some single parents especially may have to work for longer stretches of time, but the sooner that they can move in from their training and into that next job is really ideal. So our position is that we would prefer that the current statute would be kept as is. Does that make sense? Okay. It's kind of like sorry to interrupt, I'm sorry. It's sort of the fallacy of the beard. You know, when does somebody actually look like they have a beard on their face? Is it 6 hours? Is it 5 hours? It's 1 hour. What I can say is that from my experience, that people that are, that sort of languish and that are out of work longer are going to be the hardest to engage later on down the road. So the sooner somebody can move towards their certification, their vocational training, their completing their degree, typically the benefits of them getting done sooner is going to be a more positive impact on their lives.
I know someone who's taking even just 6 or 8 hours at college, and then obviously that means they're spending 10, 12 hours at least a week with the outside of classwork kind of thing. For many of them, I know getting childcare for that and childcare for work is nearly impossible, so we're kind of shutting them out of furthering their career if they don't have some other way to do it, assuming college is the direction they need to go for their career. That was just where I was going with that question.
Other questions? Representative Ousley.
Thank you, Madam Chair, and welcome back to the committee, Steve.
Be back.
I guess maybe I have more of a comment. When you said taking money from others, you said you'd circle back to it, and then you stated that there was a 40% increase in money going into other people's pockets or into Kansas families' pockets. Is that what you were referring to when you said taking money from pockets?
So yeah, I apologize for not being clear, Representative. Thanks for the question. So specifically, if there's a judgment or a child support order that they are receiving through the SNAP program to Child Cooperation Program, and they are getting their judgments for the non-custodial parent, and that parent is paying the custodial parent and family, that's a positive impact for that custodial family's budget. And if we were to consider removing the child support cooperation component, that hypothetically, and I think in reality, you would have families that would no longer being engaged with the non-custodial parent who is obligated to pay child support, and therefore would see a net deficit or lack of income coming in, like you saw with the 40% increase after the law was put on the books.
So to that 40% increase, does DCF have documentation of that?
They do.
Is DCF still on the line? Can they confirm?
Sandra Kimmons, are you available for a question?
Yes, I am. Thank you. I am here. Thank you, Representative Ousley. Yes, the 40% increase that is referenced, the agency has looked at that in years since then to see if we could replicate that information, and we haven't been able to replicate that report with our findings. Part of it is it's not known if those households that were being counted in that were already receiving child support services prior to receiving the disqualification notices. So this 40% that's quoted was from a specific time frame, July 2015 through January 2016, and it looked at the amounts those families were issued during that 6 months time frame. And the policy went into effect for SNAP on July 2015. So it does seem fairly quickly to have people already disqualified. However, it does look like it was a fairly small number. And the difference in the claims or the amount of child support received was $186,000 and some change. And when we compare that to the total amount of funds that's distributed to all families, it's like 0.16%. So it is, the math is correct for a subset of families for that 6 months. When they looked at collections, there was an increase of collections of 40% in just that time frame.
Thank you for that clarification. Madam Chair, if I may.
Yeah, one more follow-up, and we're
Okay.
going to move on.
I guess then I'll be brief. You said that, the enrollment in the secondary or post-secondary, and you gave the anecdotal example of somebody enrolling in a video game class. I'll just say thank you for making that anecdotable. That's not a current word I use in my vocabulary every day. But I'd like to thank you for making that clarity, because I think that goes a lot to the, food stamp fraud that everybody hears of, that somebody's trading their food stamps, for steaks or cigarettes or whatnot. And I have never seen a case of that in my life. I've heard stories about it, but I've never seen a case. And if I did see a case, there's a number to report the fraudulent abuse. And there you go. So I'll wrap it up there. Thank you, Madam Chair. Thank you, Steve.
Okay, thank you. Thank you, Stephen. That closes the opponents. And so that wraps up the hearing on House Bill 2371. So committee, we're going to work House Bill 2345, establishing the Office of the Child Advocate for Children's Protection and Services. I'll give you a chance to grab that or open it up on your computer. So committee, what are your wishes to do with this bill? Yeah, we're just going to pull the bill out and start working it. So anybody have questions, comments, amendments? Oh, yes. Jesse, could we have an overview of the bill real quick?
Yes, of course, Madam Chair. So House Bill 2345 is the bill that creates the child advocate. It creates the office, the position of the child advocate. It outlines how office in the legislative branch. It has what the office in advocate is required to do, and then items they have the authority and may do in order to fulfill their duties. It outlines confidentiality limitations on the information they receive. It prohibits retaliatory action on employees that are cooperating with the office. And it amends multiple statutes in the SINC and Juvenile Codes to include the child advocate as a person or entity that could receive information. And I'll just briefly go over those statutes. First, we have 382211, which gives them access to the official file and the social file in a SINC case. 382212, which gives them necessary access to agency records in a SINC case. 382213 gives them access to law enforcement records in a SINC case. And then 382309 gives them access to the official file and the social file in a juvenile justice case. And then lastly, 382310, which gives them the access to law enforcement records of offenses committed or allegedly committed by a child under the age of 14, gives the child advocate access to those as well. So I am open for any questions or anything else regarding House Bill 2345.
Okay, do we have any questions about any of the wording of the bill? Okay, thanks, Jesse. Yeah, we're open for discussion. Representative Ousley.
Thank you, Madam Chair. Committee, I do have a pair of amendments here, and I would ask Fran to pass the paper copy out and maybe of the Amendment 1. And Jesse, if you could give us a brief overview of the Amendment 1.
Yes, Representative. So Fran is helping hand out a paper copy of the First Amendment. I've also emailed that to her if you would like an electronic copy at some point as well. So let me pull up the amendment and share that on my screen. So what we have is an amendment for House Bill 2345. On the first page, we have in line 32, inserting the amendment that I referenced during the brief, during the hearing, where it includes the joint appointment by the governor and the Chief Justice of the Supreme Court. And then it strikes "and" just to make that comma grammatically correct. On page 2, we have in line 28, instead of the Office of Judicial Administration, we have Juvenile Courts here. We have Juvenile Courts. Okay. If we go to the third page, we have in line 6, we have struck the language for number 3 that says conduct an independent review of any entity that has been the subject of 3 or more review requests in a calendar year, all the way to line 9, and have inserted the language to compile, collect, and preserve a record of complaints received and processed that may reveal concerning patterns to be addressed. So that would take away the independent review of an entity, and direct the child advocate to do the preservation and collection of that. And since we are taking out that language of number 3 in line 13 and in 15 and 16, we've taken out a reference to that previous language. In line 27, we have, instead of Office of Judicial Administration, we have Juvenile Courts. And then again in line 37 on that same page, instead of the Office of Judicial Administration, we have Juvenile Courts. This was requested language in regards to who actually has custody over the child, and who is working with the child, since it wouldn't be the Office of Administration. Next, on page 4, it makes, in line 3, it makes that same change for Juvenile Courts. Line 17, in regards to when the child advocate may file any of its findings with an appropriate court with jurisdiction over a child in need of care case, and issue recommendations for that. We've included a child in need of care case in line 17 as a proceeding. Line 25, instead of Office of Judicial Administration, we have Juvenile Courts as well. And then lastly, at the end of section 2, this amendment includes and conduct an independent review of any policy, procedure, and practice that is subject of a complaint submitted as provided in this section. So that would be only the policies, procedures, or practices related to complaints to the child advocate. And then a new subsection that would impose some limitations regarding any duty or action of the child advocate in these sections shall be independent of the judicial and executive branches of the government. And then 2, nothing in this section shall create a cause for delay of court proceedings or excuse any court, district attorney, guardian ad litem, or other agency from their duties in the proceedings related to the child. And then no review of the complaint would require any licensed professional to engage or not engage in conduct required or prohibited by a governing professional code of responsibility or conduct. And then new section 3, this is in reference to when information can be released. So language from line 35 to 37 has been struck and specified that annual reports submitted required to section 1 and amendments thereto shall not be disclosed until they are disclosed to the legislative committees in those reports. And then lastly, in line 22, that is another change from juvenile courts to judicial administration. And I would like to clarify that this amendment, the one I have on the screen now is the correct one. On the first page, on the Well, so this D1 on page 2 should not have juvenile courts, but there should be a juvenile courts on page 1. So on page 1 in 2, in line 26, that should be the juvenile courts rather than judicial administration. Whereas on page 2 in line 28, instead of that striking out Office of Judicial Administration, that should be kept as the office. I'm sorry about that and not having that clear. So if you just switch page 1 and 2 for that change, that would be the amendment for today. So I am willing to answer any questions about the amendment.
Okay, thanks, Jesse. I think first I'll turn to Representative Owsley and let him explain his amendment.
Thank you, and I thank you, Jesse, for the overview. And committee, now that Jesse's explained to us what we're looking at, I'll give you a little explanation of how we got here. And what was just discussed about switching it from page 1 to page 2 will make more sense, because in the second amendment, we redefine child, and there's no longer entities listed underneath that so much as services provided. So the first one, the Chief Justice of the Supreme Court, that was always the intention. Jesse went over that in the overview of the second one. I think she did a good job of explaining, the juvenile courts versus the Office of Judicial Administrations. This amendment was brought to us by an email I received before the hearing that had objections from the Kansas District Judicial Courts Association. And they had submitted oppositional testimony last year as well, and I had forgotten about that, and I had not circled back with them. And they were unable to get their testimony in before the committee hearing that we had in opposition. So I worked all weekend long with the Judges Association to address their, and Jesse as well, to address their issues with this. The real change in this amendment is going to be on page 3 and 4. Page 3, where we strike subparagraph 3, that original wording gave a lot of entities angst, and it was rather broad and undefined, as well as the 3 or more review requests. And I'll mention that new section 2, subsection A is all the shall, and new section 2, subsection B is all the may. So we struck that language, inserted this language so that new section 2 still reads and gives purpose to creating those processes. Then on page 4, inserting the child in need of care was just an oversight upon the initial draft, because if you read that sentence, it said, the investigation court, the investigating agency, but is prohibited from intervening in a divorce, protection from abuse, juvenile offender. A child in need of care case should have been in there all along, and that was pointed out to us by the Judges Association. And in a compromise, we came up with new subparagraph 11. This will replace the wording from subparagraph 3A, and it will be conduct the independent review of any policy, procedure, or practice that is subject to a complaint submitted as provided in this section. So that really, I think, narrows the target of this office, while narrowing it to a scope that it has to be of a child in need of care, a child alleged to be in need of care, and not just any entity that provides services for a child in need of care. It has to be case specific to conduct that independent review. Then if you go down to new section 3, the way it was originally worded would have breached judicial code and confidentiality clauses. So we made sure to specify, and Appleseed mentioned this in their testimony. This was the one recommendation that Kansas Appleseed had for the bill, was to specify that that is for the report due to the legislature. And with that, Madam Chair, I would stand for questions.
Representative Owsley, would you like to make a motion regarding your amendment?
Yes, and I would move my amendment.
Second. Okay, we have a motion by Representative Owsley and a second by Representative Hoy. Is there discussion? Questions? Representative Neighbor.
Thank you, Madam Chair. I would just like to thank Representative Owsley for doing a lot of this cleanup and making the wording consistent throughout the bill. So, I think it defines things a little bit clearer for people. So I hope we can get this bill out. Thank you.
Thank you. And I would echo that. I know personally that he worked on it all weekend, and these are some of the issues that gave me angst last year too, the concerns that the judges had. So I really appreciate you coming back with all of this. Other Representative Wagoner.
I think this makes a lot of sense as far as a change. I just want to clarify. So the reports the Office of this child advocate would do, they're going to just compile, collect, and preserve a record of complaints received and process that may reveal concerning patterns to be addressed. They have that, and then there is an annual report, or not. There's an annual report. Is that?
There will be an annual report due to the legislature.
And that's in. Is that this down here on page 4? This kind of revised section, or where am I missing that? I know it's.
I believe it's in new section 1.
If I
think I
may direct
found
the
it.
committee.
Yeah.
Yes, Representative Jesse, thanks.
Yeah, thank you, Madam Chair. So the annual reports that would be given to the legislature would also be given to the governor, the committees that are overseeing, and then also the Office of Judicial Administration. That is on page 2, line 24. It's that section D. And then later in section 4, that's in regards to that information being confidential until that report is released to the committees.
Very good. Thank you.
Okay. Any other questions, discussion? Representative Penn.
Thank you, Madam Chair, and thank you, Representative Owsley, for working on this. There were a lot of concerns that I had originally going through this bill, and I'm glad that you've addressed some of them here. Would like to ask quick questions concerning, okay, so we're moving that. Concerning the change on page 3, line 8-9 area. Would you be amenable to leaving in, since this is supposed to be, I would imagine, teeth going against DCF for some of the things that we've been reading in the newspapers, weaving that language at the end of that clause back in, that is including but not limited to Kansas DCF, or any guardian ad litem, and leaving the language that you are submitting in?
The new definition of child will encompass that, because it'll be any child in the custody of the secretary. So that will capture any DCF concerns. The main reason that we scratched number 3 is because it's under the shall and not may. And so at this point, you're always going to have 3 complaints against DCF, KVC, St. Francis. And if we directed this office that you shall, take that independent review to any entity that receives 3 cases or 3 report reviews within a calendar year, that's going to consume the entire resources of the office and take away discretion from the advocate themselves to maybe deal with an individual report that was so alarming and detailed that they really want to dive in and do that independent review process.
Yeah, and I get you on that as far as, and there could be abuse in that whole situation as well, running up the board on 3 investigations at will and triggering that same response. It was just the language of putting out the notice, hey, this is coming after Kansas DCF or families or guardian ad litems, putting them on notice that is directly applicable to them, is just a measure of comfortability in that language. Let me ask you, going over to page 4, please. And we're looking at paragraph 3, line 6, and line 20, paragraph 7. It talks about the access, inspect, and copy relevant child records held by the clerk, any Kansas court, institution, law enforcement agency, and so forth, as well as utilizing the resources of the Office of the Attorney General as necessary. Now, I wasn't in that paragraph, including, I wasn't there for all the work that you guys have done over the summer or the years that you put into this one right here. But my concern is that that is a lot of information for one official to be able to access. And if they are not the most scrupulous of individuals, when you flip over to page 5,
Representative Penn, we're just addressing what's in the amendment right now.
okay.
I think your comments are appropriate when we get back to the bill.
Okay, I'm sorry.
Unless I'm in the wrong place. Okay. Did you have other questions or comments regarding the amendment, the changes? Okay. Okay. Any more questions, comments on the amendment? Okay, Representative Owsley, you may close.
Thank you, committee, for bearing with me, and I will close on this amendment.
Okay, committee, all in favor say aye. Opposed? Same sign? Okay. We can report the bill as amended. Representative Owsley.
Madam Chair, let's roll the dice and see if we can get two for two here today. And while Fran's passing that out, Jesse, could I get an overview of Amendment 2?
Yes, Representative. Let me pull up that amendment to share on the screen as well. All right. So for this amendment, going over it, what it does on page 1 in new section 1A1, it amends the definition of child. So it strikes the from line 11 or receiving all the way through line 14 administration. So it would read as in the custody of the Secretary for Children or Families, or who may be alleged to be a child in need of care, as provided in KSA 382201 at SEEK, which is the SEEK code. And then down in line 34, it changes and to or. That was just a grammatical term of 6 years or until an successor. So then on page 2, we have page 2 in line 12, we have included or any relevant joint committee. So what this paragraph does is this regards the office's position in the legislative branch and how the compensation of the child advocate is overseen by children and seniors and public health and welfare. And this bill then includes or any relevant joint committee. Since the Joint Committee on Child Welfare Oversight is not law or in the statutes, it couldn't necessarily be referenced. So this would capture that. This reference is also made on that same page in line 28. After welfare, it would say any relevant joint committee. And then in line 35, at the beginning of section 2, it would state that such reports, and this is speaking to the reports to the legislature, the governor, the Office of Judicial Administration, that those reports would not include any names or personally identifiable information of the children, the guardians, or the families in the complaints. And then line 37 would also include that report be going to any relevant joint committee. And then in line 39, it changes it to section 3 because this section 3 is in regards to any confidentiality. So any information that is confidentially protected by section 3 would not be included here. On page 3, on line 14, it would add that one of the items the office shall do is to receive and exchange records as provided in the SYNC and the Juvenile Code. In order to make inquiries and review the relevant information. And then in line 33, it strikes all of the language from line 33 to 41 and instead inserts records as provided in the SYNC or the Juvenile Code related to the complaints received, and that the office may also access all written reports of child abuse and neglect maintained by the secretary related to the complaints the office has received. And then the sections would be redesignated in accordance with those new sections. In line 43, we've added a comma in order to make it more clear that they communicate privately after consultation with treatment professionals and service providers. And then it goes on to continue listing who they may communicate privately with. And then on page 4 in line 6, this would strike all of section 3. So it would just take out the ability to access, inspect, copy relevant records, etc. in that section. And then lastly, on page 5 in line 6, this makes it more uniform with the previous amendments you saw, the language using 382201 at SEEK and 382301 at SEEK in regards to what confidentiality requirements the office is subject to. And I'm available for any questions on this amendment.
Jesse, Representative Ousley, you want to make comments?
Thank you, Jesse. Thank you, Madam Chair. So again, I think Jesse did a pretty good job on this. She's done an excellent job on this, guys, to be honest. The new definition of child, I really liked it because if we were to miss one of these silos listed here, and as our juvenile justice reform is occurring, services could be coming from other places, and as the Families First Safety and Prevention Act gets taken into place, so this really focuses it upon the child and the services they are being provided, not the provider. That way, if that child's receiving services, it's all encumbered. So I was happy with this change. I thought that really clarified things, and honestly, kind of a fail-safe on my part. But and then she explained the or any relevant committee. If the oversight committee were already established, I would probably have this just read the Joint Oversight Committee on Foster Care, but since it is not established, we cannot reference it. But I think that this is a pretty clear understanding of where we're going with that. Such reports shall not be included in names or personally identifiable. I do not know if children and seniors or public health and welfare can go into executive session, but the Child Welfare Oversight Committee, when established, should have the ability to go into executive session should such information need to be, presented to the committee. But meanwhile, this is just another classification guardrail. Page 3, this is, again, just to make sure it's in line with the JO and the SYNC codes. Really, all of this just is. If you move down further on page 3, line 33, where all that language is struck, all that language fits right into that paragraph off to the right in the amendment, and just kind of cleans up the language of the bill, and again keeps it uniform and in compliance with our SYNC and JO codes. And Jesse, correct me if I'm wrong on this. Page 4, lines 6 through 10. That's all stricken because it's covered underneath the JO and the SYNC codes as well.
Jesse?
Yes. So the statutes that I mentioned earlier when briefing the bill in regards to adding the child advocate as having access, those are the records that are referenced in this paragraph 3 that we've struck.
Okay, thank you.
Thank you, Jesse. And with that, Madam Chair, I would move my amendment.
Okay, we have a motion to amend. Is there a second? Representative Neighbor seconds. Any further discussion, questions? Representative Wagoner.
No, Jared, I think this looks good. I just want to clarify, you took out, this says, under def, child means any child who is in the custody of the Secretary for Children and Families or who may be alleged to be a child in need of care, and that's it. I mean, and so child in need of care, those are the foster kids? Or is that beyond children in the foster system?
So a child alleged to be in care could be partaking in our Families First, is it prevention services? But still have parental custody intact. But that would capture those with parental custody still intact, but alleged to be a child in need of care. And then any other child that has had, any child in the custody of the Secretary, the parental termination has already occurred. They are now in the custody of the Secretary.
And Office of Child Advocate just by name is broad, but this is making it, but I take it the intent was always related to the foster care system. Is that correct? And this just sort of makes it more clear?
Yes.
Okay, all right, thank you.
Representative Helmer.
Thank you, Madam Chair. I hope I'm not asking the same question, but I just want to clarify. So when you're striking this 3 on page 4, you're doing that because it seems like it's pretty redundant of page 3 down here on A, and A is maybe more explanatory, but you've struck that too, so I'm kind of confused about that.
Representative Ousley.
Jesse, correct me if I'm wrong. By replacing the language in 1 on page 3 and as provided in the sync code and the JO code, that really replaces everything that's struck on page 3 and on page 4, because it references the entire sync code, not a specific KSA of that sync code.
Yes. So that new language on 3 encapsulates what's struck on page 4. And then additionally, those extra statutes that have been amended are those statutes that will give the child advocate that access that they are seeking and have in that new section 1 and 2.
Okay, thank you, Madam Chair.
Further questions on the amendment? Okay, seeing none. Representative Ousley.
Thank you, Madam Chair, and thank you, committee. This has been 4 sessions, a couple interim committees, 3 years worth of work to get us to this point, and we are down to the nitty-gritty details, and that's what we're working on here today. I wanted to introduce them to the committee as technical amendments, but I felt there was too much, A, for one amendment, but then B, to just call it a technical, even though nothing in here changes the intent of the bill. I think it actually better explains the intent of the bill. One thing I learned over the weekend is really how hard it is to put your intent into writing and put it down upon paper and not have it misinterpreted. So we put in guardrails, we put in clarifying languages. When this bill was originally introduced, I think it was 23 pages. It's currently down to 18, and I think we'll lose another paragraph on this. So I feel like all the work coming up to this point today has really given us a better product, and I cannot tell you how many eyes have been put upon this and how many people have helped me, but this is certainly not, I am merely the deliverer of all this work, and I know that everybody else that's put work into it cares about our kids in Kansas dearly, and they're willing to sacrifice their weekends over it as well. So, Madam Chair, I close on my amendment.
Okay, on the amendment, all in favor say aye. Opposed, no? Okay. The bill is amended. Back on the bill, is there any other discussion? Representative Neighbor.
Thank you, Madam Chairman. Just for the purposes of conversation, I would move that we pass out House Bill 2345 out favorably as amended.
All right, we have a motion. Is there a second? Representative Vaughn. Okay, any further discussion? Representative Penn, did you want to talk about? Okay, Representative Penn.
Well, thank you, Madam Chair. I know that we're getting short on time, so I'll try to be brief. I have a number of issues with the bill as written. Again, I wasn't here on all of the discussion in the long months and years that y'all have put into this. My concern basically goes into two, if not three, main areas. Number one is the amount of power that is collected into the Office of the Child Advocate, as we asked the Child Advocate from Missouri. And that is that we see in page 4, previous to the amendments, page 4, 5, 6, 8, 9, 12, 14, and page 15, 17, and 18, different lines enclosed in there. The lack of accountability, there's one piece that we saw on the bill. Let's go to page 5, new section 4. Talks about how an employee of the office shall be immune from suit and liability if they're doing good faith performance. And the question is, where's the teeth for bad faith? They have access to a lot of information, and if they utilize that in an inappropriate fashion, are there any penalties there? We talked about the unfettered power and how that could leave us liable if they did something incorrect, that we would lose funding, such as federal funding. And then the other piece is a lack of provision for the removal of this child advocate. They serve at the pleasure of the governor, is housed inside of the legislature, is that correct? And the question becomes, they have a 6-year term, but they don't necessarily come out of that 6-year term. I didn't see any language about that.
Representative Ousley, would you like to respond?
I can try to respond. The retaliation clauses, I mean, if you break the law, you break the law. There's going to be other statutes on the book to deem with a rogue employee or advocate for that matter. And I believe they are addressed in the adjoining KCAs attached to those statutes. So, and then your second concern, it is a powerful office. That's why we spent the weekend, putting guardrails in place and, referring back to other statutes where there are other consequences, put in place as well. This one office will probably now have to follow more ethical codes than any other office because they do have such a broad reach. And we tried to make that very clear. As far as the removal process and the serving of the governor, half the reason we're here with all these amendments right now is I got the impression from my colleagues in the House that holding it in the Department of Administration was not gonna jive with some people, that perhaps they felt it was not independent enough. So we moved it to the legislative branch, and that was certainly not a seamless transfer. I believe we can make it work. We do it with the legislative post audit. As far as the governor's appointment and the Chief Justice of the Supreme Court with Senate confirmation, that is straight out of Missouri law where they are held, where the OCA is in the executive branch. Nebraska has their Inspector General of Child Welfare housed within their legislative branch. As far as I know, nobody else has brought up any, all the eyes and ears that I've had put on this and spoken with, that's not been raised an issue. I will say the physical location of the office has been brought up to where is the legislative branch going to physically house this office. I don't have those details yet. It's my understanding that there is governmental buildings that can be leased. The LPA, for example, is underneath the legislative branch and leases space within an executive branch office. The termination process is absent. I will believe that in statute there is somewhere a mechanism for removing a rogue appointment from office. I cannot identify that statute for you today. I'd be happy to dive further into that and get back with you upon that, because the last thing we want is a rogue advocate with that authority and that amount of information.
Thank you for the opportunity to reply, Madam Chair. Mr. Ranking, I would be more comfortable with that language, either reference to it over there on page 5, section 14, to those penalties, just to, if it's already in statute, that way at least somebody fresh and new like myself can see that. If it's already a matter of statute, that's a simple change. And perhaps going forward, or even as an amendment to this, I don't know how much longer we want to prolong this, but having that termination portion in there, stating that with the new committee that would be stood up, the oversight committee, a simple majority of that, or a simple majority of both houses, since this is housed in the legislature, for that termination piece. And that goes not because of the party of the governor, but it is literally the protection for whoever might be in the minority in the future. Is immaterial of party. We want to have somebody watching the sheepdog, as I said before. Thank you, Madam Chair.
Thank you. Thank you for your comments. And yes, that the discussion that we've had is that we would give some of those powers to the Oversight Committee. We just can't address it yet until that bill is passed, and we can take care of that further down the line. Further discussion on the bill? Okay, Representative Neighbor, you may close. Oh, Representative Esau, I'm sorry, I didn't see you.
I wasn't loud. I'll make it really short. I normally would not say this. We could trust that as this bill gets to the Senate, that if we see we really need this amendment on here to be comfortable with it, that we all storm the Senate and say, make this amendment. And that would be one option if we're just concerned but want to address it and don't want to slow down moving the bill forward. Just a comment.
Sure. Good thought. We can also address it on the floor. Yeah. Okay. Representative Neighbor, you may close.
Thank you, Madam Chair. I think we've had great discussion on this. I think some great work has been done on this over the years. This is not something that has been just in and out of this committee without lots of ears and eyes and comments. So with that, I will close and ask that we pass out House Bill 2345, favorable for passage.
Okay, you've heard the motion to pass out House Bill 2345 favorably as amended. All in favor say aye. Opposed, no. Okay, thank you. The bill is passed. Okay, we're running late. Thanks, we're adjourned.